Good afternoon. Can you hear me?
I can hear you, Your Honor.
You're in the jail now.
Thank you. On the record, the matter of the people of the state of Michigan versus Joseph Kelly, file number 23-03293FY. Counsel appearance.
Good afternoon. Assistant Public Defender Lawrence Sutter, appearance on behalf of Mr. Kelly for today's arraignment.
You're Mr. Joseph Kelly?
Yes, I am.
Okay, Mr. Kelly, today's the date and the time set for an arraignment. I have a felony complaint here. It alleges that on or about October 31st, 2023, at the area of 135 South Fairview, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of controlled substance, possession of methamphetamine or ecstasy, and that you did knowingly or intentionally possess methamphetamine contrary to Michigan Compiled Law 333.74032BI. This is a felony with a maximum penalty of 10 years in prison and or $15,000 in fines. Count 2 is a weapons carrying concealed. It alleges that you did carry a dangerous weapon, that being a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, that being a Chevrolet Traverse, and that this was done contrary to Michigan Compiled Law 750.227. That's a felony with a maximum penalty of 5 years or $2,500 in fines, and a mandatory forfeiture of the weapon or device is required under MCL 750.239. Count 3 is weapons, firearms possession by felon. It alleges that you did possess a firearm when ineligible to do so because you had been convicted of an attempt armed robbery, a specified felony that is punishable by imprisonment of 4 more years, and the requirements for regaining eligibility had not been met. This is contrary to Michigan Compiled Law 750.224F. That's a felony. The maximum penalty is 5 years and or $5,000 in fines. There's a mandatory forfeiture or of the weapon or device required under the law. Count 4 and 5 are weapons, felony, firearm, and allege that you did carry or have on your possession a firearm, that being a pistol, at the time that you committed or attempted to commit the felony. And count 4 is possession of methamphetamine, and count 5 is possession of a firearm by felon, and that this is contrary to Michigan Compiled Law 750.227B. Both count 4 and 5 are felonies. Maximum penalty are 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. And again, there's a mandatory forfeiture of the weapon or device required under the law in both counts 4 and 5. There's an habitual offender third offense notice. It says, take notice that the defendant was twice previously convicted of a felony or an attempt to commit a felony, and that on or about September 12, 2007, he was convicted of the offense of uttering or publishing in violation of Michigan Compiled Law 750.249 in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about November 30th, 2011, he was convicted of the offense of attempt armed robbery in violation of Michigan Compiled Law 750.529 in the 30th Circuit for Ingham County, State of Michigan. Therefore, defendant is subject to the penalties provided by Michigan Compiled Law 769.11. That makes the penalty twice the maximum sentence on the primary offense or a lesser offense. The maximum penalty cannot be less than the maximum term for the first conviction. Mr. Kelly, do you understand the counts read in counts 1 through 5, as well as the habitual offender notice?
Yes, I do, Your Honor.
Do you also understand the maximum penalty attached?
Yes, I do.
Okay. You have the right to be represented by an attorney. You're represented by Ms. Sutter from the Office of the Public Defender for the purposes of your arraignment today only, but you have the right to have an attorney represent you at each stage of the criminal prosecution. You also have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office appointed to represent you at the expense of the public. Do you understand your right to counsel, sir?
Yes, I do, Your Honor.
Mr. Is he requesting court-appointed counsel?
Yes, he is.
Okay, Mr. Kelly, you have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you have the right to stand mute. If you stand mute, this matter will proceed through each stage of the criminal prosecution all the way to your trial. You have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt by proving each element in each of the charges being brought against you beyond a reasonable doubt at a trial. You have the right to confront in court any other witnesses that are called against you and cross-examine them. You have the right to call your own witnesses to your trial or present evidence at trial that you believe further defense to the charge being brought against you. And you have the right to remain silent at trial and not have silence be used against you. You understand your rights so far?
Yes, I do, Your Honor.
Because you are being charged with felonies, you have the right to a preliminary examination before proceeding to a trial. And you have the right to have that preliminary examination within 21 days of today's date meaning the date of your arraignment. You're currently scheduled for a probable cause conference before Judge Michael Anthony Flores. It's going to be Thursday, November 9th, 2023 at 9 o'clock in the morning. You have a preliminary examination before Judge Flores on Thursday, November 16th, 2023 at 9 o'clock in the morning. Did you get a copy of your notice to appear?
I do, Your Honor, right here.
Okay, you may appear via Zoom for the probable cause conference. However, your preliminary examination must be held in person at the court, okay?
Yes, Your Honor.
Okay, at the time of your preliminary examination, you have the right to require the prosecutor to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and then sufficient probable cause to charge you with the crimes. Do you have any questions so far, sir?
I don't, Your Honor.
Okay. For the purposes of your arraignment, the court will enter a plea of not guilty on your behalf. Are you currently employed?
Yes, I do construction. I'm self-employed with me and my cousin. It's getting kind of slow out there, though. It's getting cold.
What's your home address?
407 South Clemens Avenue, Lansing, Michigan, 48912. So be my
Your phone
wife.
number?
517-515-8004.
Are you currently on probation, on parole, or out on bond in any other matter?
Yes, Your Honor.
Which one? On bond?
Yeah, I'm on federal supervised release.
Okay. And do you have a matter pending as well?
Yeah, Eaton County. Yeah.
Mhm.
From
So
2015.
you're out on bond as well, correct?
Yes.
Counsel, you can address bond.
Thank you, Your Honor. I did have a conversation with Mr. Kelly this morning regarding this case. He did advise me much the same, that he is employed, that is full-time when he is able to get the jobs that he does doing roofing and siding. And he has been consistently employed in that for quite some time. He's a lifetime resident of the Lansing area, and he does have a family and children here. He does have 4 children in the home that he assists in caring for. He did advise me that any prior assaultive or violent criminal convictions he has are over 10 years old at this stage. And understanding that he is currently on release in another county, I do not believe in this matter that he is a danger to himself or the community or a flight risk, as he did advise me that any prior failures to appear in court are almost 10 years old or over 10 years old at this stage too. So I would ask the court to consider a personal recognizance bond in this matter today. Thank you.
When's your next court date in Eaton County?
Start trial in January, ma'am. January 9th, I think it is, or 16th or something like that. We got it written down at home.
Okay. You're being charged in this particular case with 5 counts, all felony counts, in addition to a habitual offender notice. 3 of those counts, or 4 of those counts, are relative to possession of a firearm. If true, would mean that while you're out on bond and you cannot have a firearm, and you're a felon, which allegedly cannot have a firearm, and on federal supervision, allegedly not having the ability again to have a firearm, that the allegations are that you were not only committing these actions, but violating your bond and federal release. Personal recognizance would be completely inappropriate because it would, if true, it would indicate to the court that he does not follow the court orders. So personal recognizance would be denied. A bond is set at $20,000 cash surety. While out on bond, you are to follow all your previous conditions from your other bonds. And in this particular court, you need to report to pretrial services within 48 hours of your release. You're not to use, purchase, or possess firearms or any other dangerous weapon. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to engage in any assaultive or threatening behavior. Do you have any questions about your bond conditions?
No, Your Honor. I was just wondering if we can get 10%. Is that what that is? 20,000?
No, it's 20,000 cash surety.
So that's okay.
Okay. Any additional questions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further.
You're all set, Mr. Kelly.
All right, thank you.
On the record, in the matter of the people of the state of Michigan versus Cortez Biggs, file number 23-03199 SM, counsel appearance.
Good afternoon. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Biggs for today's arraignment.
Are you Mr. Cortez Biggs?
Yes, ma'am.
Okay, Mr. Biggs, today is the date and the time that's set for an arraignment. I have a misdemeanor complaint here. It alleges that on or about July 30th, 2023, at the area of 5711 South Martin Luther King Boulevard, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of domestic violence. It alleges that you did make an assault or assault and battery upon a Deanna Parker, a resident or former resident of your household or an individual with whom you had a dating relationship, that this was done contrary to Michigan Compiled Law 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty, sir?
Yes, ma'am.
Okay, you have the right to be represented by counsel, and Ms. Sutter from the Office of the Public Defender is representing you today only for your arraignment, but you do have the right to have an attorney to represent you at each stage of the criminal prosecution, and you also have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office appointed at no expense to you. Do you understand that?
Yes, Your Honor.
Okay, is he requesting court-appointed counsel?
Yes, he is.
Mr. Biggs, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You have the right to plead not guilty, and you have the right to stand mute. If you stand mute, this matter will proceed to a jury trial. You have the right to a jury trial, and you have the right to the presumption of innocence at your trial. That presumption of innocence will continue until the prosecutor can prove your guilt beyond a reasonable doubt. And they do that by proving each element of the charges being brought against you beyond a reasonable doubt at your trial. You have the right to confront in court your accusers and any witnesses that the prosecutor intends to call against you. You have the right to cross-examine those witnesses. You have the right to call your own witnesses to trial or present evidence that you believe further a defense to the charge being brought against you. Do you have any questions so far?
Oh, ma'am.
You have the right to remain silent at your trial and not have silence be used against you. You also have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. You're currently scheduled for a pretrial conference before Judge Tony Flores. It's going to be November 14th. So that's a Tuesday at 9 a.m. Did you get a copy of your notice to appear in the Zoom instructions? Can you hear me, Mr. Biggs?
Yes. Yes, I did
Okay.
get one. Sorry.
Oh, okay. Okay. And so you can't appear via Zoom for that so long as you have video capabilities and you're not doing anything that would distract you from performing an official court proceeding. You do not have to appear via Zoom. You can appear in person because we're open to the public, okay?
Okay. Yes, ma'am.
Purposes of his arraignment, is he pleading not guilty?
Yes, Your Honor.
Court will enter a plea of not guilty on your behalf. Are you currently employed, sir?
Yes, I work at Kroger's in Hope, Michigan.
What's your home address?
5722 Barron Drive.
What's your phone number?
517-515-9968.
You can address bond counsel.
Thank you, Your Honor. I did have a conversation with Mr. Biggs this morning where he did advise me that he is a lifetime resident of the Lansing area with significant family and friends in the area. He did also tell me that he is employed at Kroger in Holt, working 20 to 30 hours a week and has been gainfully employed there for quite some time. He advised me that he has no prior assaultive or criminal convictions and that he would have no problem appearing either in person or over Zoom for any necessary hearings. I do believe with appropriate bond conditions like the no contact order I discussed with him this morning, that he does not pose a danger to himself or the community, nor does he pose a flight risk to the court, and I would request a personal recognizance bond on his behalf today. Thank you.
I don't see any prior convictions on his criminal history. Are you currently on bond or on probation?
No, ma'am.
Bond will be set in the amount of 500 personal recognizance. While out on bond, there's a no contact order that will be in place for the protection of the alleged victim, Deanna Parker. You're not to have contact directly or indirectly with Deanna Parker. Do you understand that?
Yes, Your Honor.
You're not to be within 1,500 feet of wherever she is. You're not to be at her address. You're not to cause any other person to make contact on your behalf to Ms. Parker. Do you understand that?
Yes, Your Honor.
Also, while out on bond, you're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to possess a firearm or any other dangerous weapon. And you need to make sure you come to all of your court dates on time, okay?
Yes, ma'am.
Do you have any questions about your bond conditions?
No, Your Honor.
Additional matters for the record, counsel.
Nothing further. Thank you.
You're all set, sir. On the record in the matter of the people of the state of Michigan versus Shakir Rogers Jameson, file number 23-02850FY. Counsel appearance.
Good afternoon. Assistant Public Defender Lauren Sutter, appearance on behalf of Mr. Rogers Jameson for today's hearing.
Okay, Mr. Rogers Jameson, how are you today?
I'm doing actually pretty good.
Okay, you feeling better?
Yeah, I'm feeling a lot better. I'm feeling, a lot more aware of things going on around me and the things that I need to do to take care of those things, like my children and my family. I made
Very
mistakes.
good. Yeah, I get it. I just want to know if you're feeling better. Last time I saw you, I had to find good cause to go beyond the 21 days because you needed to be hospitalized or just go to the hospital, I believe. There was an ambulance that came to court for you. But you're feeling better today?
I found out I have scoliosis, but that's something that I'm dealing
You're
with.
getting treatment for that. Okay, I'm glad to hear that you're taking care of your medical issues. Now let's see if we can get you to take care of your legal issues. You have two alleged violations of your bond conditions. I have a bond report here. Indicates that you were arraigned by the magistrate back on September 15th. And she gave you the following conditions: that you were supposed to report to pretrial services within 48 hours of your release, a pretty standard bond condition for those who are being charged with a felony. It states here that on the 21st of September, the reporting investigator attempted to contact you when they didn't hear from you, left a voicemail requesting a return phone call. They followed back up with you allegedly on the 3rd of October. And they spoke with your attorney, Ms. Wanji, who provided your email address and your mother's telephone number. 2 days later, on October 5th, the reporting investigator allegedly emailed you requesting that you contact pretrial services for enrollment. 5 days later, October 10th, the investigator contacted your mother and left a voicemail for you to contact pretrial services. It says at the date of this memo, which this was dated for October 11th, they had no contact with you as it relates to your condition to report to pretrial services.
Yes, Your Honor, I apologize. I have had a lot of things going on and
Mr. Rogers Jameson, I'm gonna advise you not to talk anymore.
Okay.
I have another alleged violation. This one alleges that you violated the terms and conditions of your bond violations, which was do not have or cause any third party to have any contact directly or indirectly with the Deanna Stately. It states here that you allegedly violated the terms by being within the area of approximately 15 feet of wherever Ms. Staley lives, works, or goes to school on or about October 31st, 2023 at 17:40 hours. So in each of these alleged violations, you would have the right to have a contested hearing. You would have the right to be represented by your attorney at those hearings if I find that you were in violation of your bond conditions. That's a contempt of court. And that would mean that you will be facing a penalty for contempt of court maximum penalty is 93 days in jail and or $7,500 for each separate violation. Do you understand that?
No, actually, I
You don't.
don't.
Okay,
I
so
don't understand.
you have two separate allegations that you violated your bond. One was the bond condition that you were supposed to report to pretrial services within 48 hours. The other allegation is that you violated the no contact order as it relates to a Deanna Staley. So in each of those alleged violations, you have the right to have a hearing where the prosecutor must prove by a preponderance of the evidence or providing evidence beyond a reasonable doubt, actually, that you violated your terms of your bond. Do you understand that?
I understand that part.
Okay, if you're found to be guilty of violating your bond conditions, then you would be facing penalties in each violation of up to 93 days in jail and up to $7,500 in fines for violating your bond. Do you understand that?
Because that's how much my bond is set to.
No, that's because that's the maximum penalty for a contempt of court order.
I didn't know that. Okay, thank you.
Okay. Okay, and so nonetheless, for the purposes of his arraignment, is he pleading not guilty to the violations?
Yes, Your Honor.
Okay, you can address the bond.
Thank you, Your Honor. I did have a conversation with Mr. Rogers Jameson this morning. He did advise me that he is still working in the Lansing area at the Spartan Handyman Services that he's been part-time at for a number of, or a period of time. He is a lifetime resident of the Lansing area, and I do understand the nature of the alleged bond violations here. He was previously on a 7,500 10% bond. I would ask the court to consider, along with admonishing him and reminding him of his bond conditions, including the no contact order, to consider re-releasing him on this bond with something like an added GPS tether to continue monitoring him on bond. So at least he is able to continue working while he is dealing with this case. Thank you.
Okay. Mr. Rogers Jameson, I do recall that you did appear to all of your previous court dates. Maybe you misunderstood when the court advised you at the time of your arraignment that you must report to pretrial services within 48 hours. What's your phone number?
517. This is my new phone. I just got this phone because I haven't had one, but it's 517-490-3951. I couldn't remember it earlier, but
Let me make this crystal clear. We're not going to stalk you and track you down. You're going to make contact with pretrial services because that's the court order. You understand that?
I understand completely, 100%.
And you're going to contact them immediately upon release. Within 24 hours of release, I want you making contact. I don't care if you have to track down your mother and get the voicemail that was left there. I don't care if you have to walk all the way to the circuit court and meet with them in person. You make it happen. Do you understand that?
I will. I'm fully capable.
The no contact order means you can't have contact directly or indirectly for any reason. And I did review the allegation in the bond violation. I think it involves you being at the hospital allegedly with the mother of your child and your child. There was no caveat or any option for you to go if you believe something was wrong with your child. There was a no contact order. You understand that? And if you want that amended so that you can have contact with the mother of your child as it relates to childcare, then either your attorney must make that request appropriately at the time that you're before the court, or you got to go to the family court and get an order for that. Do you understand that?
I do now, yes. Thank you.
You can't just violate your bond conditions or else you'll end up in jail. Do you understand that?
Yes, I understand completely.
I'm going to continue your bond at this time. I'm not going to impose a GPS tether because I don't believe the nature of the contact warrants that at this point. I'm going to trust that you and I now have a complete understanding of what your bond conditions are, correct?
Yes, we do.
What are you going to do within the next 24 hours? Mr. Roger Jameson, what are you going to do within the next 24 hours? Can you hear me?
I can now.
I
Okay.
can't yet. Sorry.
You can't hear me?
I can hear you now. I apologize. You were robotic before.
Okay, sounds good. What are you going to do within the next 24 hours?
Gonna contact child services. I'm gonna definitely, and then yeah, I guess that's all I got to say.
Okay.
And also,
okay. And for what reasons are you allowed to have contact with Miss Deanna Staley or Tony Staley?
none at all unless I go to family court for my daughter to be able to, or have my attorney request.
Very good, very good. Any additional matters for the record?
Nothing further.
You're all set, sir.
Thank you. You'll have a nice day.
You too. That's all I have.
Thank you, ma'am. Have a good rest of your day.
Have a good rest of
Thank
your day.
you.